Thanks, everybody. A lot of you have covered this and maybe in some of your talks today, but as we know, from Argentina to India, from Pakistan to most recently Ecuador, we've witnessed something of a concatenation of sort of animal personhood developments with these historic opinions citing this growing body of, at least while not binding, at least persuasive international precedent as their own foundation, which paints the U.S. in somewhat stark contrast, insular and unmoving as our jurisprudence has been for roughly the past quarter century on the matter of animals' legal status, which I think marks this tacit recognition of a group of Colombian hippos as legal persons in our federal courts just this past year as a seismic shift, and one that I hope will open the door to new animal legal personhood developments in the U.S. To come. And so with that said, I'll note that the U.S. features a very fractured and complex multi-jurisdictional system featuring sort of individual state courts and our federal court system, which also features numerous districts and circuits, each with their own sort of jurisprudence, at least until a higher court establishes binding precedent for them. Given some of the rather limited time for this talk and the subject of the talk, I'll be focusing primarily or exclusively on the national framework, again, both for the sake of time as well as the fact that animal legal personhood has yet to be recognized in any of our state courts, and some of you might have read the very recent happy decision that came out in New York against the Non-Human Rights Project. So with that said, I'd like to start by offering some context for the prospect and the promise of personhood, which in the U.S. Law is framed as a necessary element of standing, or this threshold that the courts need to meet, or the plaintiffs need to meet in order for the courts to hear their case. And the very first high-profile case to address this question came out of our Ninth Circuit, which is often pointed to as our most liberal. So in a nutshell, the government was failing to uphold the protections that it was required to observe for the palillo under our Endangered Species Act. And as you can see here, notably, the plaintiffs in the case were the palillo as species, a number of organizations, and one or two sort of human advocates. And our Ninth Circuit recognized the palillo's legal personality under what I've offered here as a much more simplified but hopefully clearer standing jurisprudence, which was, if you were protected by the law, then you constituted a legal person under that law. And if you were a legal person under that law, it was basically dispositive that you had standing legally to bring your case and to sue. And the logic was clear, simple, and uniform. And this formula was the exact same formula that was applied to humans and corporations. And so the question was, well, why should it be any different for non-human animals? And so the message to advocates was, well, there's no real need to list yourself as co-plaintiffs for animals. It's the harm to them, not you, that matters legally, but also potentially morally as well. And the harms to us as animal advocates or as animal organizations, that's just secondary and rather unnecessary. And so our federal standing threshold criteria were easily satisfied. So if we could demonstrate that there was a legally cognizable injury to an animal caused by the action or even the inaction of a defendant, and the court had in its power to redress that particular injury, well then animals could be plaintiffs in their own right, and we could bring cases in their name and on their behalf. And this framework was tested in 2004, again in the Ninth Circuit, Cetacean v. Bush, which concerned the government's use of sonar in different areas that was impacting the world's cetaceans, which were protected under these as well as other laws. But our Ninth Circuit balked at that previous determination that this prospect of animals being legal persons under the law. And their rationale was that only Congress, who created these rights, along with the executive who may or may not have signed them into the law, could dictate who actually held rights under these laws. And it was under this comedy of branches principles that we saw a new, if simplistic, rule of statutory interpretation. So we look to the statute in question to determine Congress's intent as to who or what should be a legal person under a particular law. And so we frustrate our previous framework. And so, yes, if we have an injury in fact, if and only if there's an injury to an animal that then harms us as a statutorily protected person. The causation element remains the same, so it was caused by the action or the inaction of our defendant. But the redress requires not only that the court be able to remedy the injury to the animal, but that in doing so, that we actually benefit from that remedy. And so what this effectively required was that statutorily interested parties experience the harm more or less firsthand, but also that we experience the relief. And this may seem like a rather low threshold to meet, but when we consider that animals are being harmed, or the animals who are being harmed are most likely in the actual possession of the defendant, this bad actor who can readily conceal these same animals and the harms they're committing to these animals from our view, well, then the crisis of how to actually employ animal protection laws to protect animals becomes painfully evident. So sticking with the Ninth Circuit, we've seen organizations like PETA put this comedy of branches principle to the test, largely for strategic or impact litigation purposes to engage the public. First, we had this Tilikum versus SeaWorld case back in 2012, in which they asserted that this captive orca, Tilikum, was being forced to perform in violation of the 13th Amendment's prohibition of forced labor and thus slavery. And then in 2017, we had this Naruto case, which some of you heard Professor Abate talk about during his presentation yesterday. And here, PETA sought to argue that Naruto, this Japanese macaque who took this so-called monkey selfie, was the copyright holder of that same image. And they turned to this next friend statute that gives one standing to bring a claim on behalf of a legally incompetent person, sometimes a child, but also maybe somebody who is disabled, and in this case, under the Federal Copyright Act. And there were two rather obvious problems here. First, Naruto was not considered a person under either the next friend or copyright laws. And second, and arguably more importantly, PETA had never met Naruto. They didn't even know where he was or whether he was alive or not, or even if he would have had an actual interest in asserting a copyright claim whatsoever. They had no connection to him. And the Ninth Circuit didn't hesitate to sort of beat this last point home. And when they did, PETA attempted to quickly settle with the defendant, but the court didn't necessarily allow them to do that. And as clever as some, I think this case to be, the fear that our earlier cetacean case, that court sort of tacitly considered was, well, this prospect of organizations using animals as somewhat ideological pawns and bringing some of these ideologically minded or even frivolous lawsuits to advance sort of their organizational goals, their organizational agendas. And regardless of whether we might frame those agendas as moral in the sense of advocating for animals more generally. And so what these cases in the Ninth Circuit left us with was this question of, well, what is the landscape concerning the legal personhood of animals? And so with the Supreme Court, we have only silence. But with the lower courts outside of the Ninth Circuit, what we have is arguably dicta, as those cases sometimes also had human co-plaintiffs or either reference Palila as persuasive precedent in offering sort of their own assessment that animals could be plaintiffs. And then we also had our Ninth Circuit, sort of this comedy of branches principle, which arguably I think would find purchase in most of our circuit courts if additional personhood cases were to be brought in them. And again, so the idea is that we look to the statute to determine congressional intent as to whether animals might be persons, and to date, we have none of those. So again, a pretty bleak landscape for animals and the advocates who are bringing cases or attempting to advocate on their behalf. But if there's one thing that we say in our animal law courses, it's that animal law attorneys have to be some of the most creative lawyers doing this, working in the legal sphere, precisely because there are so few options, and the options that do exist are often taken away from us. And so one such attorney, Ariel Flint, who works for the Animal Legal Defense Fund, discovered this prospective pathway last summer in the form of 28 U.S.C. 1782, which Congress passed to offer discovery assistance to foreign courts. And the principle behind the law was to advance this comity of nations principle, meaning that, at least in this case, we assist foreign tribunals and parties with discovery requests within the U.S. that would otherwise prove beyond sort of the jurisdictional reach of those courts, with the hope that they too will then reciprocate and offer our courts that same benefit. And so these discovery requests are usually ex parte, meaning that only one party to the foreign proceeding actually is petitioning the U.S. District Court for discovery. And to make that discovery request, the applicant has to show, among other things, that the discovery target, usually a person, but sometimes a document, is located or resides within that district where they're making that application, that the document is actually for use or going to advance their cause in the foreign proceeding, and the most important one, that they are actually an interested person with regard to that proceeding. Now, like with many of our statutes, the law doesn't stipulate who qualifies as an interested person. But there's this really compelling Supreme Court case, Intel, that held that litigants undoubtedly meet this measure. In addition, I won't go over these because they're not particularly important, but there's also some leeway for the appeal to court to consider discretionary factors in determining whether providing or granting the discovery order is appropriate. And with the Supreme Court stipulation that litigants no doubt qualify, and our general comity principle, which calls us to, again, turn to the statute to determine Congress's intent, with Congress itself telling U.S. courts to actually look to the foreign tribunal under this comity of nations ethic, it became a question for us of, well, who is this right animal litigant, which posed a challenge in and of itself. And I'll say here that the Animal Legal Defense Fund works principally, if not exclusively, in the U.S. and the U.S. alone. And so it was at this point that they brought me on as a consultant because my area of expertise is international law and animal legal philosophy. And what we sort of paid witness to in our analysis of the landscape were these numerous pronouncements of animal rights and personhood across the years. And the fundamental question was, is it really personhood as it entails being a party to a case, that is, being able to sue? Or is it personhood in a moral or ethical sense, and that animals have rights or are persons for purposes of being visibly moral or morally visible before the law or in the eyes of the law? And just to offer a few examples of the landscape today, some of you have already heard about the Cecilia case, but in this case, the animal protection organization AFADA brought a habeas corpus petition on behalf of Cecilia. Luckily for our purposes and for Cecilia and for the advancement of animal law, AFADA was they were removed as a party from the case because they did not actually have organizational standing to do so. And so the only entity in whose name the case could be brought was Cecilia herself. And what the court observed was that it wasn't necessarily the the fact that Cecilia was confined, but the nature of her confinement violated her habeas rights. And so she was removed from this basically this cell to Brazil, to this sanctuary. And we also saw Estrellita. So this actually happened very recently with the courts in Ecuador observing that animals are subjects of rights and are protected under this rights of nature paradigm, and that animal rights has this procedural dimension to it, meaning that not only are animals protected, but that they can actually go to court and have cases brought again on their behalf. And I think the last presenter observed a couple of Indian cases, and we had these historic pronouncements, 100-page decisions coming out of India, which employed much of this language of legal rights and legal personhood, and sometimes maybe going a bit too far with arguing that non-human animals also owed legal duties and had legal liabilities just like a human person. But when we really sort of interrogate some of these decisions coming out of India, and these were authored by Rajesh Sharma, they seem to suggest more that animals have legal protections and that all humans have a duty to enforce those legal protections. So it's not so much that animals can be parties to a case, but that animals' interests should be brought by all humans who have a duty to protect their interests. But again, it's somewhat unsettled. Some of these decisions came out, 8, 10 years ago, and we've yet to see actually any cases being brought in the actual name of animals. And then we have the Kavan case that came out of Pakistan a couple of years ago. And in this case, the court observed that humans or citizens of the state have this constitutional right to life, which implicates a right to a healthy environment, and that non-human animals constitute those objects of a natural environment. And so our claim to life, our right to life, implicates nature, of which animals are objects. But even in this case, a lot of the pronouncements, a lot of the newspaper clippings were saying that Kavan is that animals have rights in Pakistan, that Kavan is a legal person, but the actual case seems to suggest otherwise, or at least doesn't go that far. Although advocates right now on the ground are trying to get the courts to sort of make that connection. And so again, the implication of the usage of these terms sort of reaches across boundaries, has transnational, has international implications, and in this increasingly complex sort of animal law landscape, we have to attend what is both lost and what is potentially gained in that legal sort of translation. To wit, our first fundamental goal when we were working on this case was finding that particular jurisdiction or those jurisdictions that viewed animals as quote-unquote proper persons who could actually be plaintiffs. And the second was actually finding the plaintiffs themselves. And some of you might have, outside of this legal personhood announcement or ruling out of the U.S., might have heard about Pablo Escobar's cocaine hippos, whom he actually bought from a ranch in Texas and took to his compound in Colombia, where naturally they multiplied with the herd as of the time that this case was brought, having grown to, I think, over 100 or so, and really just devastating the environment and attacking residents nearby. And the government planned to either exterminate them or to use a particular sterilization agent that would cause harm to the female hippos. So in turn, a Colombian lawyer, some of you may know by name, Luis Domingo Gomez Maldonado, was preparing to file a suit arguing that they should be sterilized using a particular agent rather than being killed. And when we contacted Luis Domingo, the principal question was, could this suit that he was bringing on behalf of these hippos actually be brought in their names without himself or any organizations or any other humans listed as co-plaintiffs. And some of you may be familiar with this Chucho case, the spectacled bear that was decided maybe 8 or so years ago. But basically, the Supreme Court of Colombia affirmed that this trapped bear was subject to habeas corpus. And the next year, the Constitutional Court overturned that determination, arguing that habeas was inapplicable because it applied only to humans. But it did not decide that non-human animals could not have any rights, but that habeas corpus was not one of them. And the court also observed that given Chucho's age and physical infirmity, that he would just not be, that not enough analysis had been done with respect to what it would do to him to actually move him away from his confinement. But since that particular case, we've seen a number of very progressive decisions coming out of Colombia. The first being the recognition of the rights of the Magdalena River to protection, to conservation, to restoration. And actually, the Magdalena River is where these hippos resided. We also saw cases of bees having rights against the use of insecticides, the rights of dogs as members of the family, among some other decisions. And so, acting on their behalf, to advance the case for contraceptive use over killing, Luis Domingo prepared to file a U.S. discovery request. And basically, to meet these elements, we had to show that the discovery targets here, wildlife experts who lived in the District of Ohio, and who actually had direct knowledge of the use of this particular type of contraceptive that we wanted to use, resided in this district, so pretty easy, and that their testimony was going to be of use for this forum proceeding. Again, a pretty easy element to meet. But critically, the question that we didn't know how the court would rule was as to whether these hippos actually qualified as an interested person. In Colombia, they were litigants, but we just didn't know would our actual U.S. court system accept that as valid, or would they be frightened by the prospect of animal legal personhood. And a week later, we received the order granting the application. And some of you may have seen some of these press releases and news reports basically heralding the recognition of animal legal personhood in the U.S. But just like the implications of what constitutes legal personhood may differ by jurisdiction, received a number of sort of questions and even criticisms as to whether or not this pronouncement might have overstated the gain. For example, some observed that the court didn't actually rule that hippos were legal persons. And the question that we asked in response was, well, did it need to? So indeed, the court could not have granted this discovery order to these community of hippopotamuses without implicitly having made that underlying yet substantive determination that they were legal persons under this particular statute. And I'll say somewhat as an aside that our discovery application laid out how these hippos met each one of these criteria, including how they satisfied the interested persons requirements as litigants. And yet the question basically remained as to whether our judge was actually conscious of the fact that this would have personhood implications. And I actually find this to be a very compelling question. And I answer it by offering that shouldn't we want judges to check if all of the qualifications have been met and then ask whether animals should qualify? And my hope here is that judges shouldn't be thinking about whether animals meet some undefined measure, but whether they meet the listed criteria, which these hippopotamuses did. There are also questions as to whether this was an oversight by the judge or whether the judge had just rubber-stamped our particular application. And I hope the answer is no, but we couldn't say one way or another. The judge herself hasn't sort of spoken out as to the rationale behind her decision. And we also received questions as to whether, these hippopotamuses were actually litigants. And to answer this, we point to, again, these post-Chucho personhood developments from Colombia. And finally, we had this question of, well, if the fundamental principle that animated the court's granting of the discovery order was this comedy of nations question, did this really decide the question or the underlying matter of whether animals are legal persons? And here I have to say that, at least with respect to the Ninth Circuit, which is where we've seen the majority of our personhood cases take shape, the courts have never really been concerned with the legal personality of animals as the fundamental jurisprudential question. Rather, the principle that has animated their decisions up to this point has always been this comedy of branches question, so of this deference to Congress. And so if we're hyper-focused on whether the courts are looking at, animal legal personhood in a vacuum, we'd never have welcomed positive rulings in Tillicum or Naruto as, legal personhood gains themselves. Again, if the courts had ruled positively in them, it would have been somewhat of a bleak landscape for animal protection. But if we look to the courts, who again have been telling us to look to Congress, who in this case told us to look to courts abroad, what we see is that the U.S. has witnessed its very first recognition of animal legal personhood. And it really heartens me in that under the statute in question, this constituted a figurative act of legal persons, or let me take a step back, that under the statute, this constituted a figurative act of self-discovery of legal persons and by legal persons. So a U.S.-based international discovery order with, we hope, U.S. and international reverberations. So on that note, I think I would be remiss if I didn't turn back to our hippos in closing, these newly discovered persons, to note that right now the Colombian government has labeled them as an invasive species, thus potentially setting the stage for their eventual extermination. And so Luis Domingo is still fighting on their behalf and looking to petition the government to allow him to move them to a sanctuary. And so we're keeping our fingers crossed for that development. Thank you.